Hi there, you are watching a previously recorded video. If you have any questions that are very specific to your brand or require assistance with legally protecting your brand, please feel free to reach out to us at www.jnjlegalservices.com. Schedule a discovery call with us to get you on the right path to success. Finally have a fashion world example to dissect with you guys and to show you what it takes to have an actual successful trademark application. Hi everyone, welcome to my channel. If this is your first time seeing my face, I am Jaleesa, your friendly neighborhood lawyer, and welcome to another episode of our Alien in the Courtroom series, a series aimed at helping young entrepreneurs and business professionals at making better legal decisions for their brands. Today's episode is going to be a fun one, at least fun for a nerd, an IP nerd like me. We're going to be doing a lawyer's react, a review to a Parker's episode. Whenever I see anything IP related on the news, I get really excited to share my opinions or thoughts about it. So I either share it on my Instagram stories really quickly, or I'll actually hop onto camera and share it as I'm doing right now. When I was binge watching, I came upon season 2, episode 6 of the Parkers, and it is the classic legal episode that usually happens in like old school TV shows where everybody goes to court for some reason, and the reason why they go to court is an actual IP related trademark issue. In that episode, the crew, Nikki, Kim, Stevie, and T, decide to start competing fashion lines, and they're arguing over a trademark. Can't wait to share it with you guys. So if you're interested in seeing this review, this lawyer's react to the Parkers episode, then just stay tuned. As always, it is important that I stress that these videos are intended for educational purposes only. In no way should you consider me to be your personal lawyer. And if you should have any questions that are very specific to your brand, please seek outside counsel. Feel free to email me specifically if you would like to work with me on developing your brand. But otherwise, you should definitely seek outside counsel to talk about your legal issues.
What's up, guys? Really inspired.
Yeah, me too. I think I'm gonna ask Scott for his number again.
Carl, I'm serious. You know how much money we can make if we had a tight slogan? So all we need to do is think of a phrase that pays.
Hey!
Hey, that's it. Hey is our slogan.
Nobody cares about that. We say that all the time.
Right. We need something more pizzazz.
Something catchy, you know, something relatable.
Dang, Mom, I can't think of anything.
Dang mama. Now that's a slogan.
Yeah.
That's whack.
It is not. You're just jealous because you didn't come up with it.
You're just bitter because you're short.
Are you being feisty?
Hey, settle down, Daphne and Aubrey.
Right. Fine. I still don't like dang mama. I like hi.
Well, keep liking it. But this is Dang Mama Enterprises. Now, are you in or out?
It's gonna be that way. I'm out.
More for us.
When you have this many people that you're thinking of starting a business with, I know that right now they're just in the beginning stages talking about the idea, but when you have this many people, you're going to have so many different conflicting ideas involved in building this business. You actually want to sit down and draft an agreement about everybody's roles and responsibilities within the company, within the brand. So you would probably have like one person who's in charge of like creative ideas. So one person who says, this is going to be what the slogan is, or this is what the new item that we're putting out is going to be this. You probably want to have one person in charge of like operations, one person in charge of like creative decisions, maybe one person that's in charge of marketing. You really want to make sure that you divide the roles, because in the situation like this where it's hard for everyone to come to one decision, there needs to be a person that has the final say. If you're not working alone and you're working with a partner, then you definitely need an operating agreement.
Puddin', how many Dang Mama t-shirts have we sold? Count the guy that you threatened? 1.
So I want to mention a couple important things about the Dang Mama t-shirt versus the Hey t-shirt. As you can see, Hey is a lot better than the Dang Mama t-shirts. Even though they're both using a standard font, you can tell that Hey has a little bit more thought and creativity put into it. The Dang Mama shirt just looks like impact font. Yeah, impact. And the Hey, it does look like a little bit of word art. Microsoft 97 word art is being put into it with like the little curve and the Hey, which makes sense because it looks like how it's actually pronounced. So that was a little bit more like creative work, a little bit of creative mindset to it. But just to be a little bit nitpicky about this episode, whenever you are using fonts on a t-shirt, in your logo, in your slogan, you want to make sure that you have the rights to use that font. I've already made an episode on this topic of fonts in a previous Alien in the Courtroom episode. I probably explained it a little bit better in the video that will be linked above in one of the cards. Not sure which side it's on, but it's in the video there. When we as everyday people refer to fonts, we're talking about like Times New Roman, Helvetica, Impact, all the fonts that are listed on our Microsoft Office. But technically, in a legal atmosphere or legal world, the font is actually the computer code or software that you download onto your computer that shows, like, works with the computer to put out the letter that you are thinking of. What we actually think of as font, which is like the parents of the letters on their screen, is actually typeface. You want to make sure that you own the font or you have a license to use the font commercially. I want to make this very clear because often I think that I come across clients who have made this misstep, or just whenever I talk to people in general, most people do not know this. But let's say that you had a friend design the Hey, or you had a friend design your logo, whatever it is. Whenever your friend draws a design for you to use commercially, you want to make sure that you own the rights to that design. Most people, when they purchase a logo or a design from a friend, they only just pay for the logo afterwards and assume that I've paid for the work and now it belongs to me. That's not true. That is not how copyright works. Whoever creates the original work of art owns the rights to that work of art. Whenever you commission someone to create something for you, you need to make sure that you have it in a contract in writing that states that the person who's created the work of art is a work for hire, is an independent contractor, and that they do not own the rights to use that work of art. They technically still own it if you haven't purchased the rights to own it, which means that person can go forward and create whatever they want using your same mark. That is definitely not what you want to happen. Even if it was your idea to put it together, the artist, whoever draws it or creates it, puts it out into a tangible medium of expression, they are the owners of the mark. Even sometimes on Fiverr, they're just giving you a license to use that work of art. It doesn't mean that you have exclusive use of that mark, so they can go forward and still sell that design to another person. You want to make it very clear that it is not just a license to use, because anybody can use a license. You want to make sure that it is ownership of the mark. A very important thing to note about the Hey t-shirts and the Dang Mama t-shirts are that these t-shirts would not be an appropriate specimen or sample for a trademark registration. When you're registering for a trademark, you have to attach something called specimen, which is basically evidence of using the mark in commerce. Even though this mark is being used in commerce, it is not a mark that has the look and feel of a trademark. Your mark cannot just look ornamental. It has to look and feel like a trademark. To look and feel like a trademark, the Hey, for example, would have to be on the product, the clothing tag. It would have to be on possibly the corner of your shirt, like the upper right or left hand corner of your t-shirt, or it could even be on the packaging, or it can even be the title of the website, and a click to order button is somewhere next to the product. But it has to look like it's an identifying mark. When you put Hey or anything in the center of your t-shirt, your brand name in the center of your t-shirt, it does not look like a trademark. It does not look like the shirt is identifying a company. You know, usually when you see like school uniforms or like military uniforms, for example, you'll see like a little mark here, and that is an identifying source. Like, you know that this person goes to St. Mark's Day School. It looks like a mark. It looks like a symbol of ownership. If you just have it in the center of your t-shirt, the trademark office views that as ornamental design, as a design that's just meant to look cute. You don't want it to look cute, you want it to be trademark worthy. So right now, the Hey t-shirt as it stands and the Dang Mama t-shirt as it stands does not look like a trademark to a trademark examining attorney. Quickly, just to go over, there are usually two main types of trademark applications that a fashion designer would file, or any company, any brand would file. And it's usually a 1A application, which means your mark is being used in commerce, or a 1B application, which means your mark is not being used in commerce. And a 1B application will cost you more money in the long run. Not being used in commerce will cause you more money in the long run than a 1A application. So a lot of companies who are now starting their businesses or haven't started to sell products yet, but they want to register a trademark, they would actually be filing for a 1B trademark. With a 1B, you have about 6 months to make sure that you start using your mark in commerce. And after the 6 months, you can still apply for more extension, but even just applying for an extension and then when you finally file it, it will still add up to more money than or just putting the goods out there, selling, and then applying for your trademark. A lot of times you can see like celebrity brands would, or people with money honestly, would file the 1B and they haven't started selling yet, compared to filing the 1A. Let's say that T does have Hey somewhere on the product packaging, or let's say that he does have it somewhere on the product tag, like your clothing tag. Then that's going to be a good specimen to use for a trademark registration. Specifically, that would be a good specimen for a 1A application. Often I'll have people ask me about filing a trademark for their business, and again, the t-shirt or the sample isn't going to be a good specimen, but also they technically haven't started using the specimen or the sample really in commerce yet. Selling to your family and friends is not enough unless you can really show some evidence of like making the item accessible or having an ability for the public to order and pay for the item. But it is not enough to sell to family and friends to have a 1A application versus a 1B application.
See, if I had invested in T's Hey t-shirts, I'd have my money back by now. Yeah, because T is making a killing off of our slogan. You're right, Puddin', because Hey is our slogan. And we're not going to let them get away with it.
So now, as you can see, the Hey brand has extended to not only just t-shirts, but it's on mugs, it's on hats, and it's on CDs. Now, looking at all of these products with the Hey on them, these are all going to be different trademark classes. The Hey clothing, the t-shirts would be class 25. But then when you think about mugs, hats, CDs, oh, and there's even posters, all of those are separate classes. So you have to bear in mind that that is either a $225 application each or a $275 application. It depends on which one you're more comfortable with or your lawyer would be more comfortable with using. But $225 for each class that you are using it in, because as I've stated in previous episodes before, trademarks are divided into classes. And the reason why that you can have two companies using the same name is because they may operate in different classes. Dove chocolate is not owned by the same people who make Dove soap. Soap would be more so in a chemical household class, and chocolate obviously is in the food class. So whenever you have a business like this and he's expanding the product line, he has to trademark it. $225 in clothing, $225 in mugs, $225 in CDs, $225 in posters. He may even have to trademark within an entertainment services class as well, as you're going to see coming up.
He hiked up the prices on his shirts.
Everybody, let's make some noise for T and the Hey Girl.
It's so random that Miri Miri is a part of this episode as the Hey Girls. T, for example, would try to trademark Hey in the entertainment class if he really wanted these girls to be like a part of his branding. You can think of it like even the Fanta girls, and they were all like purple, orange. I like the Fanta girls, but they would be trademarked within an entertainment class as well.
Hey, Nikki. Hey, Kim. Hey, T. So, how are things working over at Dang Mama Enterprise?
Dang Mama is dead.
You know, Kim and I are the real originators of Hey. No, I don't.
We should get all the profits.
No, you shouldn't. Hey belongs to us. No, it doesn't. T, we have a right to that slogan, and I don't care what you say. So, sue me.
I'm not really gonna go into like the court procedure of it all. There's definitely some issues that I see already, but that would make this video too long, so that doesn't even make sense for this type of video. I just want to dissect the arguments for you.
Are Kim and Nikki Parker. They claim they are the originators of the slogan, Hey. They're suing for ownership of the slogan. The defendant, Thaddeus Radcliffe, claims that he ain't going out like a sucker. And he built Hey to be the booming business it is today.
Thaddeus, state your case, please. Your Honor, the only thing I tried to do was to build Hay to its fullest potential. Bottom line is, I did all the work, so I deserve all the money.
If they had actually hired lawyers in this situation, T would be the rightful winner of this slogan. And there's a reason why. Because T has started to use the slogan in commerce. It does not matter that Nikki and Kim have been using the slogan, Hey, for all of their lives. If you've never used it in a commercial setting or in a commercial sense, then you are not the rightful owners of this mark. So T is right that he's saying bottom line is I did all the work, so I deserve the money. He's right in the sense that he's the first to put this slogan onto clothing, onto CDs, posters, whatever. He's the first to use this slogan in a commercial way, so he should be the rightful owner of this mark. He has prior use compared to Nikki and Kim, who still actually have no use at all.
Stevie, who are the originators of the slogan, Hey?
Definitely you two.
Well, who blew it up? Excuse me, it's my witness.
Oh, no, that's okay. I don't mind answering. Actually, T did all the work. I must say you did an excellent job. I mean, you had the Hey Girls posters, CDs.
Your Honor, can we please have this hostile witness removed from the stand and dead?
Right, so Stevie mentions all the products that he had it on, and she said that he did all the work. So again, just because they've been using this phrase their whole lives, it doesn't mean that T actually hasn't put the phrase to good use in a commercial way, in a way that the trademark office would recognize.
Your Honor, I would like to present evidence that will prove beyond a reasonable doubt that Kim's first word was not da-da, mama, or bye-bye, but hey. Hit it, bailiff.
Hey.
Baby is cute, but the baby does nothing to help their argument because, again, it doesn't matter that they've been saying it, it matters who's been using it commercially.
Mr. Nelson, as your character Dwayne, how would you commonly greet Shirley, Raj, and Rerun? Hey, hey, hey. Yeah. Thank you. Your Honor, in closing, I would just like to add that the great baseball legend Mr. Willie Mays was known as the Say Hey Kid. And everybody remembers the cartoon character Fat Albert always said, hey, hey, hey.
So T bringing a famous actor who was known for saying hey, hey, hey to support his theory that the Parkers don't only have the rights to the word hey is very flawed in a sense, because as I've stated before, more than one person can own the rights to the word hey. All that matters is the industry that you're using it in. So it's definitely flawed to think that just because you've heard a slogan in one industry means another person can't create like a similar slogan and use it in a different industry. Because the argument isn't that Nicki and Kim are the only ones that can use hey. They're trying to claim that they're the only ones that can use hey within the fashion and whatever other industries that they want to use it in. But T has already started to use it in those industries. So T still has a stronger claim than Nicki and Kim.
I've made my case.
You haven't.
Then I will
No one has
proceed
made
with my
their case.
decision. As Thaddeus demonstrated, a moniker can be associated with an individual.
Moniker, I'm not sure. So here's where the issue with the writing comes from, because you know they just wanted the judge to sound smart, but a moniker is just like a nickname. A moniker is not a slogan or a phrase. I'm not sure why they're using moniker, but they just assume that, you know, regular TV audience wouldn't know the difference. But a moniker is not the word that you would use in this situation. You would just say slogan.
Who may subsequently lay claim to it. Yeah! Neither party copyrighted hey.
Issue number 2. Copyright is not at issue in this episode. The real issue is trademark. The judge should have said trademark.
It is also clear that hey is associated with the Parkers. I rule in favor of the plaintiffs.
They should have never won. And honestly, for the judge to say that there's like a clear association with the Parkers without any real evidence of use in commerce is such a big flaw. The whole purpose of trademark law is to protect people who are using their brand, their IP, their content in commerce. It's all about commercial competitiveness and making sure that one person doesn't monopolize a market. Trademark law is all about commerce. So if there is no evidence in this case of it being used in commerce, which every single piece of evidence had nothing to do with commerce, it only had like character evidence of whether Nicki and Kim have been saying this phrase their whole lives. Neither party has filed for the trademark, and it doesn't make sense that they're already in court to fight over a trademark that nobody even owns. There was no industry stated. And again, even in the courtroom, because you own a trademark only within certain industries, I'm not even sure if Kim and Nicki are fighting to own hey in fashion, or are they fighting to own it in cups and mugs? Are they fighting to own it in CDs and posters? Like, it's not clear. The rights that are being granted to them in this video sounds like broad rights to hey no matter what. And it's not going to be broad rights. It's going to be within certain categories, and categories that they haven't even stated in this episode, so we don't even know what's going on here.
Yes, can we help you?
I'm James. I was a court reporter during your proceeding. Y'all need to vacate this car. And while y'all at it, park over the cash.
I ain't gotta give you nothing.
This piece of paper says you do. Since you bright individuals never copyrighted hey, I took the liberty of doing it myself. I stand before y'all the proud owner of hey.
Say, you must be mistaken because my daughter mailed off our copyright papers right after our day in court. Right, Button? Anybody got a stamp?
Let's say that the USPTO didn't see the court case. Even when a trademark is filed or applied for, trademarks take a while to come in. They take about 6 months to a year. It seems like this is pretty recent from the court case. So it doesn't make sense for that. This court reporter, he's already filed. He's already been approved as ownership of the trademark, for him to come forward. And even if he came forward and say, I can't believe it, even this imaginary timeline doesn't make sense, but even if it's filed and he owns it, there's still like a time to oppose the trademark. The trademark is published for everyone to be put on notice that this person is trying to trademark in this category, and there's a time period where anybody can oppose your trademark, meaning that if they find out that you're trying to trademark their name or their phrase in the same field as them, and that they're already using it, they'll oppose your trademark, and then the USPTO would even have noticed that something sketchy is going on there as well. So it doesn't make sense that this guy just automatically has ownership of this trademark all of a sudden. It wouldn't happen. So that brings us to the end of this very long lawyer react, lawyer review. Hopefully I was able to cut it down to a point that is easy to digest and understand. I will hope so. If you have any questions or comments, please leave them down below in the comment section. If you have a question about this video or even about future topics or things that I've discussed already, feel free to let me know down below, because that just helps me figure out what content I need to keep creating for you guys. Share this video with entrepreneur or business professional, a fellow fashion designer, artist, musician. Feel free to contact me at my email address. That will be the email address that I will be communicating with you guys on. But stay tuned, because things are going to switch up around here. And I'll talk to you guys in the next video. Bye.